Chapter 13. Domicil of Particular Persons, Prisoners, Exiles, Refugees, etc. SS 272. Domicil not changed by imprisonment. As a general rule, a person does not acquire domicil in the place where he is imprisoned, but retains the domicil which he had at the time of his imprisonment. And this is so whether he is imprisoned in pursuance of a criminal conviction or on civil process, as, for example, for debt. There is no English decision upon this subject, but the rule has been recognized by text writers generally, and by numerous decided cases in Ireland, Scotland, France, and this country. It has been put upon several grounds, one being that, inasmuch as the presence of the prisoner at the place of his confinement is but temporary, he must be presumed to preserve the hope of return. Another ground which has been assigned for the rule, and probably the only true one, is that the presence of the prisoner is wrought of his own volition but by constraint, and that, therefore, one of the main requirements for the acquisition of a new domicile, that is, that it be freely chosen, is not fulfilled. This ground, which seems to be supported by the reasoning in the analogous cases of the pauper maintained in an alien's house, and the insane person confined in an insane asylum, would extend to cases as well of imprisonment for life as of a temporary nature. As was well said by Church, J. In Grant v. Daliber, the state prison not his place of abode, but his place of punishment, and while there he absent from home. SS 273. Prisoner may acquire a domicile where he is imprisoned. It doubtless would be held that, notwithstanding his compulsory presence, a prisoner might acquire a domicile where he is confined, if it could be shown that he had formed the intention of remaining after he became free to control his movements. But in such case very clear proof of such intention would be required. SS 274. Prisoner for life. With respect to the prisoner for life, the doctrine does not appear to be settled. If the second ground of the general rule stated above is the true one, it would seem that his domicile is unchanged. Several cases may be supposed, namely, of a person domiciled in Massachusetts who is imprisoned for life in New York or Canada, a person domiciled in one town or county who is imprisoned in another town or county of the same state, a domiciled Englishman who is transported to a penal colony for life. In the first two cases it is difficult, in the entire absence of authority in the affirmative, to believe that such imprisonment will work a change of domicile. SS 275. Transported convict. With respect to the domicile of a transported convict, there appears to have been much doubt in France until the law was recently settled by a statute which provides that, as to those who are condemned to simple transportation, leur domicile pour tous les droits civils dont ils ont exercisé aux colonies est où ils subissent leur peine. On the contrary, convicts who do not enjoy the exercise of their civil rights are, subject to the law of the 31st of May 1854, impressed with legal interdiction, and as interdicts are domiciled, not in the colony where they are found, but with their tutors. In England, Phillimore 3 lays it down as beyond doubt that a person transported for life would lose his original domicile, and Westlake and Dicey follow him, the latter, however, with some hesitation, in suggesting that, supposing, however, that a sentence to transportation destroys a man as domicile of origin, it is probable that no courts, other than those of the sovereign inflicting the sentence, would give this effect to the sentence. French emigrants were treated by our courts as retaining their domicile of origin. SS 276. The relegatus in the Roman law. The Roman law furnishes us with two apparently contradictory texts concerning the relegatus, who was partly exile and partly prisoner. Paulus declares, relegatus in eo loco in quem relegatus est, interim necessarium domicilium habet, and opium domicilium aut haber potest et relegatus eo loco under arciter, ut Marcellus scribit. Savigny harmonizes the text by holding that the latter means merely that the relegatus is not freed by his punishment from discharging his former municipal burdens. But Merlin, pointing out that there were two kinds of relegatio, temporary and perpetual, holds that the text of Paulus applies to both kinds, and that of Oppian only to the latter, so that one who was condemned to permanent relegation could have domicile only in the place to which he was relegated, while one who was condemned to temporary relegation had a necessary domicile in the place of his punishment, and might at the same time preserve his former domicile, in view of his presumed intention to return after the expiration of the term of his punishment. John Vogt also makes the retention of the prior domicile dependent upon intention to return, while Corvinus, without distinction or qualification, sees in the text only general authority for double domicile in the case of irreligas. SS 277, Exiles, and Udney v. Udney, Lord Westbury, in developing the extreme theory maintained in that case of the adhesion of domicile of origin, used this language: the domicile of origin, and a fortiori an acquired domicile, may be extinguished by act of law as, for example, by sentence of death or exile for life, which puts an end to the status civilis of the criminal. Whether such effect would be given by foreign courts to such sentence may well be doubted, and certainly if the period of exile be shorter than for life, or be uncertain in its duration. The domicile of the exile would not be held to be changed unless he appears, abandoning all hope and intention to return, to have adopted another domicile. Denisart says, thus one may say that an exile is not considered to be domiciled in the place of his exile, and that if he died there, his succession ought not to be regulated by the laws of the country of such residence, because, in order to fix a domicile, it is necessary that there should be a choice manifested by an express intention, and the exile is not allowed that liberty. Hope and intention of return ought always to be presumed in a relic, and consequently it may be said that, during his exile, he preserves the domicile which he had at the moment when he was banished. It is necessary to say the same thing of prisoners, etc. SS 278, ID. The case of the exile presents two aspects of compulsion, namely, compulsory absence from one place and compulsory presence in another, and it is easy to see that the presumption would be very strong against the voluntary adoption of the place of exile as the place of domicile. In the case of banishment, or prohibition to remain in a place or country, we have only one aspect of compulsion, that is, compulsory absence, leaving the person free to settle where he pleases. It is apparent that, in the first case, a change of domicile can very rarely take place, or at least be proven, unless it be held to occur by operation of law. But in the second case, it is possible to conceive of circumstances which would show that the person had so accepted the situation, and so set himself up in the new place or country, as to raise the presumption that he has no other intention or idea than to remain there permanently. SS 279, Refugees. It is a general rule that a person who is impelled by fear to flee from his place of abode does not thereby lose his domicile, nor does he gain a domicile in the place where he has taken refuge, unless it appear that he has settled there animo menendi, and the presumption is, until the contrary appears, that such person retains the expectation and intention of returning, when the impelling cause has disappeared. Mascardus, upon the authority of Eubaldus, says, Quando quis aliquo medit impulsus, res familiam sum alibi transtulerit, nonem ibi durante medu domicilium contrasis presumit. This principle has been applied to several classes of refugees. SS 280, Political refugees. The most familiar class is that of the political refugee. A striking instance of this class is given by Beaumanoir in the case of the fugitives who accompanied James II to France and who were treated by the French jurists as retaining their English domicile. And on the other hand, the same doctrine was recognized by the English courts in the case of the French immigrants or refugees during the period of the French Revolution. And since SS 281, de Bonneville v. de Bonneville. The leading case is that of de Bonneville v. de Bonneville, in which Sir Herbert Jenner, J., delivered an opinion which has been much referred to. He says, there is no doubt that the domicile of origin of the deceased was France, for there he was born and continued to reside from 1765 to 1792, and he left that country only in consequence of the disturbances which broke out there. He came here in 1793, but he came in the character of a Frenchman, and retained that character till he left this country in 1814, for he received an allowance from our government as a French immigrant. Coming with no intention of residing here, did anything occur while he was resident here to indicate a contrary intention? It is clear to me that, as in the case of exile, the absence of a person from his own country will not operate as a change of domicile. So, where a party removes to another country to avoid the inconveniences attending a residence in his own, he does not intend to abandon his original domicile, or to acquire a new one in the country to which he comes to avoid such inconveniences. At all events, it must be considered a compulsory residence in this country. He was forced to leave his own and was prevented from returning till 1814. Had his residence here been, in the first instance, voluntary, had he come here to take up a permanent abode in this country, and to abandon his domicile of origin, that is, to disunite himself from his native country, the result might have been different. It is true that he made a long and continued residence in this country, but I am of opinion that a continued residence in this country is not sufficient to produce a change of domicile, for he came here avowedly as an immigrant, with an intention of returning to his own country so soon as the causes ceased to operate which had driven him from his native home. He remained a Frenchman, and if he had died during the interval between 1793 and 1815, his property would have been administered according to the law of France. SS 282, White v. Brown. In the American case of White v. Brown, this doctrine was expounded by Grier, J., in his charge to the jury. It appeared in evidence that the testator, being a Pennsylvanian by birth, had, during the Revolution, adhered to the King of Great Britain, and in 1776, having sold part of his real estate in this country, had sailed for England. In 1781 he was proclaimed a traitor, and his real estate was confiscated. In 1788 he received compensation from Great Britain as a suffering loyalist. A greater part of his time from the close of the war to his death in 1824 was spent in England. He returned, however, to this country several times after the close of the war, remaining in all about 2 years. It appeared also that he had used very strong expressions indicating a desire and intention to return to and remain in America. In view of these facts, the learned judge charged the jury as follows: a fugitive from his country on account of civil war still retains his domicile, unless he shows an intention of a total abandonment of his country by the acquisition of a new domicile of choice. Nor will the confiscation of his property by the new government, in the case of a revolution effected after civil conflict, nor the attainder of his person, of themselves put an end to his domicile of origin. If he elect to adhere to the old sovereign or government, looking forward with hopes of its re-establishment, his domicile of origin is not necessarily abandoned by such election. Allegiance to the existing government, or the exercise of political rights, constitute no part of the definition of domicile. These facts may nevertheless be of great importance in judging of the intention. Consequently, adherence to the King of Great Britain in our Revolutionary War, although it might have caused the forfeiture of the life or property of an American citizen, was not of itself an abandonment of his domicile. The estates of those persons who fled from England with the Stuarts and died in France were administered by the French courts according to the law of England as their domicile. The jury found in favor of the American domicile, and, on the motion for a new trial, the court sustained their finding. SS 283, Ennis v. Smith. The general doctrine was also recognized by the Supreme Court of the United States in Ennis v. Smith, but we may draw from that case the doctrine that voluntary exile because of unwillingness to live under a particular government does not prevent a change of domicile, even though the hope be entertained of a change of government such as will permit a return without violence to the feelings of the person so circumstanced. SS 284. Fugitives from the horrors and dangers of war. The general rule has also been applied to persons who have fled to avoid the horrors and dangers of war, particularly civil war. The passage above quoted from Mascardus has reference to such case. This doctrine has been applied also to municipal domicile in this country. SS 285. Exile or fugitive may acquire domicile at the place where he takes refuge. It is scarcely necessary to cite authority that an exile or fugitive may acquire domicile at the place where he takes refuge, if he sees fit to do so, and that he may be assumed to do so if he continues settled there in a permanent manner after his restoration to his own home has become possible. SS 286. Absconding debtors. In Udney v. Udney, Lord Westbury said, speaking of domicile of choice, there must be a residence freely chosen, and not prescribed or dictated by any external necessity, such as the duties of office, the demands of creditors, or the relief from illness. In that case, however, the English acquired domicile which Colonel Udney left on account of pecuniary embarrassments was held to have been completely and finally abandoned and lost, and Lord Chancellor Hatherley seemed to consider it a circumstance in favor of such abandonment that his return to England was barred against him by the continued threats of process by his creditors. Here there was evidently no animus revertendi, but in several other cases of similar absence it has been held that no change of domicile takes place if there is animus revertendi. Thus in Pitt v. Pitt in the House of Lords, all the facts tended to show the intention of Colonel Pitt to return, if and whenever he could get rid of his liabilities. In Briggs v. Briggs, Hannon, President, held that absence to avoid creditors were no change of domicile where there was an animus revertendi in case the party could make enough money to pay off his debts. And to the same effect was the Virginia case of Lindsay v. Murphy and Jennison v. Hapgood, the testator, domiciled in Massachusetts, left that state to avoid his creditors. Budd did not remove within his family, who continued to reside where he had left them, and upon this important fact the court based the presumption of animus revertendi, and held that his domicile was not changed. In all these cases in which a change has been decided against, it appears to have been upon the ground of express or presumed animus revertendi, and hence that the new residence was more or less temporary, while Udney v. Udney itself seems to be a refutation, or at least a contradiction, of the doctrine of Lord Westbury.